Hi, this is Cora Stack here, Dr. Stack. I just wanted to wish all my friends and connections on this small YouTube station a very calm, peaceful, and happy weekend, as I always try and do. But also, I wanted to say that I'm very disappointed, really, that that I feel that I have been under surveillance for quite a long time and not able to report it. And I mean, this is like Geraldine Kennedy, the second, and Bruce Arnold the second. This is the same thing, as far as I'm concerned. I investigate a lot of, I do research, I apply my mathematical methodology to do a lot of research in a lot of different policies areas, including whistleblowing. That's only one of many, many areas. And I also look at how investigations are done. So for example, if you go into, if you make a if you're involved in making a complaint, say, and you look at how that investigation is carried out. Now, it might be relevant to your own life or it might be relevant to somebody else's life, but you might look at the investigation, the procedures, and you might see a lot of flaws. And in particular, you might see that the majority of them side with the institution. Sure, isn't that collusion? I mean, there's no, if it's widespread, isn't that collusion? Isn't that part of corruption? That kind of collusion. And people would be there saying, well, we're doing an independent investigation, but we're paid by the institution, so there's an automatic conflict of interest there. And how has that been allowed to happen for so long? So this is widespread. All of this. These investigation, and I'm saying this is a complete waste of time. So you have all these bullying investigations and protective disclosure investigations of hospitals, too, every public body oversights, and the vast majority of these investigations side with the institution, and these are like outsourced to the private sector, solicitors or all kinds of people like this, earning a fortune by and large. Now there are some that don't side, that do not side with the organisation, but they seem to be by and large in the minority. So what's the point in having all of this waste of time investigations which are actually not delivering accountability for the taxpayer, or indeed honesty or transparency for the government that are paying ultimately the taxpayer? So what I'm saying is we need a new system. We should be looking or examining at different systems of dealing with these kind of disputes. And I'm saying arbitration first before courts could be offer a much better solution. It's novel. It's not in any other country. We have arbitration in the workplace relations, which is working very well. Although generally speaking, people from institutions will come lawyered up, versus the north, but not always, not always. So there have been some big progress there, but that's not enough really, because that's only workplace disputes. There are disputes. There are a huge amount of disputes too. So the hospitals and all public bodies. Bullying and harassment, protective disclosures, all of those kind of things, and the money it costs and the time it costs even to do one investigation. Even the ombudsman, all the children's ombudsman, the guard ombudsman, the amount of money spent on these investigations is massive, and they cannot do the amount of the complaints. They're overwhelmed with complaints. So a lot of them will be gaslighted out, and they'll make up, they'll say they can't do it or it doesn't satisfy this or that, because they just haven't got the resources. So rather than having it all complaints, and this is all very divisive, then it divides people rather than gets any real solutions. It seems to me we need to look at arbitration as an option for dispute resolution in everything. And this is really part of my campaign message, which didn't get through because of all the blocking. And even protective disclosures, I'm saying, should go through arbitration at the first. Now, penalisation against protective disclosures, that's I suppose you could have that against any complaint procedures. To mean every complaint procedures, if you're a complainant, you could be penalised for making a complaint. So, that whole issue of penalisation could be extended to any complaint procedures. But I think a better way forward is through examining, the benefits of having an arbitration first system for all complaints and all disputes, to try and resolve disputes which are inevitable in life through an arbitration system which would be state funded, so that everybody would have access to it. And also what I'm saying is that mental health, like psychologists, trauma informed mental health psychologists, psychiatrists, all of this, that angle should be brought in, which is not in the current court system. I mean, it's legal, but it doesn't really examine the psychological issues that can arise with high conflict disputes. For example, if you look at the work of Bill Eddy, he's been saying for years and years in America that in a lot of these conflicts there are mental health issues, underlying pathologies in the people engaging in endless litigation, and it's usually one side. That's the other side that he's saying, that in a lot of cases it's not the two, there's one side that's driving the high conflict litigation, and that's usually an underlying mental health issue. And really we should be, rather than, what he tries to do is mediate with these kind of personalities, dysfunctions. We should be trying to actually help these people resolve their dysfunctionality, by having them, having therapy for them to try and see whether they can be helped. And then the cases that cannot be resolved through the arbitration system, have to be escalated to the court, and in particular constitutional issues automatically, and everything then is supervised by the court. So this is my big idea, really, I suppose, to try and have a better system of dispute resolution, since it seems to be causing such huge dispute at every level, and having it at local level, and maybe local councils could have control over that. Or I won't say control, but could manage the local disputes, so that you'd have local democracy, more local democracy, and then going up and up and up towards regional ones, and then government arbitration and so on. Maybe local districts, maybe that kind of thing, local arbitration to the district, or whatever way you'd organise it. But perhaps you'd have better outcomes from a district arbitration. Not court, but whatever words you want to put it up with, court, but just district arbitration model than a district court. Because you'd have arbitration rather than this black and white kind of system, which generates division, has a far more impact. So I'm saying the legal system as it is, and Bill Eddy would say this very much so. I've looked at a lot of his work, generates division. But what I'm seeing is the arbitration needs to be part of the legal system. To try but the mental health professions, mental health should be brought into it, so that the people that have these dysfunctions are helped, if they can be helped, at the earliest possible stage, and that's identified, try and be identified. And no big deal if someone has a dysfunction. Everybody has, there isn't a person who isn't affected by some strain of mental health, or isn't on some kind of spectrum. It's your personality style. Everybody has a different personality, but it's when it goes out of the extreme, and it becomes problematic, that people need help, and often that's missed, certainly very often missed in the court system, because judges do not have experience in mental health, or training in psychology or anything like that. And anyway, the court system seems to me not fit for purpose for dealing with many disputes, bar the constitutional ones, and really ones that are not, cannot be resolved through an arbitration first system. So this is my principal kind of message that I wasn't able to get through because of the 5-minute block. So I'm saying that that this really should be very seriously considered, and I do feel that being under surveillance for such a long time, for trying to bring this message to the public, is completely unacceptable. Really, it's very unacceptable and very disrespectful, extremely disrespectful to someone of my intellect and my intelligence and my dignity, and my sense of fairness and justice. And I would ask these people to stop it, just stop it. But it's sort of a joke with these people now, and they call me Miriam, and I suppose that the next thing now is they'll start calling me Geraldine, every other name they could get, and was I sorry I didn't get the nomination, all this sort of slagging me off like this. I mean, I would never go into them and start slagging them off. I think Justin Kelly needs to get hold of these people and just teach them a few manners. I won't go any further. No point. So they're not all like that. Of course, there's some very, very good people in this organisation, but making a joke out of me, and having me on some kind of pulse, with allegedly, it sounds very much like Maurice McCabe. I can't get my pulse records. It sounds like Maurice McCabe. They've been tampered with, interfered with, or else false lies have been believed about me, because of the misogyny that's often in these kind of places. Or, well, maybe there was some other more sinister aspect to it, like the Maurice McCabe issue. And am I a whistleblower? No, I just study whistleblowing, but I study a pile of other things as well. So I mean, I'm not a one-man band, no, far from it. So I think it's very unfair the way I've been treated. But I want to focus on what next week. And one of the points I was trying to make today was that I felt that looking at the judgment of Justice Liam Hamilton, that it was very weak in that it really didn't stand up enough to the government for what they did to Geraldine Kennedy and Bruce Arnold, and it wasn't enough of a sanction or a threat to try and stop the government from frightening the press. And what's needed in the next judgment is a much stronger message to the government that they cannot, frighten the press and undermine the freedom of the press going forward. So that was the point I was trying to make today, and that only came to me from the research I was doing in the last few days. And I do not want, people mocking me, for doing research which is a very serious, it's so beyond what they would be able to do. And I don't mean this in any kind of deprecating way, but it's so beyond their ability to understand what I'm trying to do that the disrespect is completely, I know it's a bit of a joke, but it's gone beyond a joke. It really is. And just ask these people to stop it and let me get on with doing my work, which is trying to solve huge problems, but particularly freedom of the press, and this tyranny, and this sense of dictatorship that we now live under, the fear and the silencing. And it's once it comes from the top, it's going everywhere. So it has to stop somewhere. So I'm asking the judiciary to actually examine, think of the judgment, my argument about the judgment of Hamilton, and to say that they really have to reverse the damage done by that. I don't know how they're going to do it, but certainly they have the power to do it. It is a common law. They have discretion, so they do have discretion. So I would urge that they would use it widely to make sure that there is freedom of the press, because without freedom of the press, there is no democracy. It's as simple as that. Why should I stand up for the press when the press hardly mentioned my name in the past few weeks? Well, maybe they might mention my name a bit more in the next few weeks, but that's not the reason that I would want them to do it. But I think it's the principle of the freedom of the press is so important for a proper democracy. And it was very clear to me, going around, that the press were terrified, and I can't say they were in collusion with the government, but fearful of perhaps a lot of their funding being withdrawn, and that's their ability to pay their bills, etc., etc. So there's I've mentioned several of the reasons earlier, but it hadn't. It was only when I looked at the judgment of Hamilton and kind of thought about how that could have impacted the freedom of the press, years going forward, that I thought, yeah, no, it was a very poor decision by Hamilton, who was an excellent judge in many other ways. And I hope now the judiciary will reverse the huge damage possibly that caused. That caused, in spite of the appearance of being a good judgment. No, no, it actually was a very, very poor judgment, in my opinion, for freedom of the press when you examine it forensically, as I have over the last couple of days.